Thank you very much, Damien. Karla?
Good morning. Saigo Sabaguego, Gawaniosta Yungyats. My name is Karla General. My Mohawk name is Gawaniosta. I am a citizen of the Mohawk Nation. I was raised in upstate New York on the Akwesasne Mohawk territory, and I want to thank you for inviting me to participate in this forum on global violence prevention. And I want to today provide an introduction to the issue of violence against Indigenous women in the United States and opportunities to combat this epidemic of violence, and share some of our work, such as our recent success at the World Conference on Indigenous Peoples at the United Nations. I'm an attorney at the Indian Law Resource Center. I've worked there for about 5 years. We are a nonprofit law and advocacy organization established in 1978 by American Indians, and we represent Indigenous peoples and tribes throughout North, Central, and South America on issues of land reclamation, protection of resources, and human rights, and in their environments as well, and their self-determination and sovereignty. These centers, Safe Women, Strong Nations project in particular, works to end the epidemic levels of violence against Indian and Alaska Native women and children, and its devastating impacts on Native communities by raising awareness of this issue nationally and internationally, by strengthening the capacity of Indian and Alaska Native nations and Native women to prevent violence and restore safety to Native women, and by assisting national Native women's organizations and Indian and Alaska Native nations to restore tribal criminal authority. I use the term American Indian and Alaska Native because the U.S. views them as distinct. There are 566 federally recognized tribes in the U.S. 229 of those are Alaska Native nations. The statistics regarding the epidemic of violence against Indigenous women in the U.S. are horrifying. You might have heard that American Indian and Alaska Native women are 2.5 times more likely to be sexually assaulted or raped than other women. 1 in 3 will be raped in their lifetime, and 3 in 5 will suffer physical violence. The murder rate on some reservations is 10 times the national average. And Native women and children are especially vulnerable to human trafficking. I think 44 tribes are located within the proximity of the U.S., Canada, U.S., Mexico, and Russia borders, and close to international shipping routes. They're also vulnerable to impacts from extractive industry, where corporations or mining interests target reservation lands, which generally are more prone to being vulnerable to extractive industry and capitalization on the resources, as well as lack of the criminal authority to prosecute crimes committed by outsiders coming onto Indian lands and taking advantage of the situation. These are statistics recognized by the Department of Justice. These are their statistics, and these are statistics that do get reported. So we imagine the situation to be much, much worse than is actually, that we actually know of, that's documented. Violence, however, is not traditional or customary, and it cannot be separated from colonization and the impacts of colonization today. The disproportionately high rates of violence against American Indian and Alaska Native women are largely due to an unworkable, discriminatory U.S. legal system that severely limits the authority of Indian and Alaska Native nations to protect their women and girls from violence, and persistently fails to respond adequately to acts of violence against Native women and children. Together, these factors create a situation where American Indian and Alaska Native women are denied access to justice and to meaningful remedies, and are less protected from violence than other women simply because they are Indigenous and because they are violated on tribal lands. Indian tribes, Native women, and their advocates have successfully worked for important reforms in the United States law in recent years. These reforms promote the collective rights of self-determination and self-government recognized in the United Nations Declaration on the Rights of Indigenous Peoples. The U.S. has recently improved its laws by enacting legislation such as the Tribal Law and Order Act in 2010 to enhance existing tribal sentencing authority from 1 to 3 years, and as well as the tribal provisions in the Reauthorized Violence Against Women Act of 2013. That act was a major achievement for American Indian and Alaska Native women in the United States because in 1978, the Supreme Court stripped tribes of their authority to prosecute non-Indians for crimes committed on tribal lands. And it took 35 years to regain this authority with the Violence Against Women Act. That act specifically restores a limited version of tribal criminal authority over certain non-Indians that commit domestic violence, dating violence, or violate tribal protection orders within the tribe's jurisdiction. Of course, the damage was done by then after 35 years, so we're working to reverse a lot of that right now. Since the act was signed into law on March 7th, 2013, the Department of Justice approved 5 tribes to participate in a 2-year pilot project. On March 7th, 2015, the end of the statute's 2-year waiting period, the law authorized all tribes across the country to begin exercising criminal jurisdiction over non-Indians, so long as all the statutory requirements for implementing this are met. There's a lot of due process provisions and other provisions requiring certain things of tribal courts and the licensing of tribal judges and such. As of September 1st of this year, 8 tribes have implemented the Special Domestic Violence Criminal Jurisdiction over Non-Indians under the Violence Against Women Act. These tribes are the Pascua Yaqui tribe in Arizona, Tulalip tribes of Washington, Confederated tribes of the Umatilla Reservation in Oregon, Sisseton Wahpeton Oyate in South Dakota, Assiniboine and Sioux tribes of Fort Peck Reservation in Montana, Little Traverse Bay Bands of Odawa Indians in Michigan, the Seminole tribe of Oklahoma, and the Eastern Band of Cherokee Indians in North Carolina. Together, they have made 42 special domestic violence criminal jurisdiction arrests, resulting in 18 guilty pleas, 5 referrals for federal prosecution, 1 acquittal by jury, 12 dismissals, and 6 cases are pending. Unfortunately, in most of these cases, children were involved and were victims of violence as well, and were unable, much of those cases remain unprosecuted because the law does not cover children. Nearly 40 additional tribes have participated in the Intertribal Working Group on Special Domestic Violence Criminal Jurisdiction and are in varying stages of preparing to implement the restored jurisdiction. 20 tribes report that they expect to implement the jurisdiction in the next year. Unfortunately, not $1 has been appropriated to support this jurisdiction. Many significant barriers remain. Some I already mentioned. Indian nations must first meet stringent requirements to use the new laws, and this, coupled with the lack of sufficient funding for implementation, may delay, deter, or even prevent tribes from proceeding at all. Even where tribes do exercise the new jurisdiction, it is limited. Tribes are generally unable to prosecute many non-Indians who rape, murder, stalk, or traffic American Indian and Alaska Native women. Strangers may also still enter reservations and commit violent crimes with impunity because there must be a nexus in the relationship of the non-Indian to the tribe. And children are left unprotected by the new law. Among the most egregious legal barriers still existing in the U.S. is the one impacting Alaska. Native tribes and Alaska Native women, all but one of the 229 tribes in Alaska, are prevented from exercising the restored criminal jurisdiction over non-Indians, available to nearly all other tribes, simply because of the way the United States classifies their land. They're not included in Indian country, which is a very restrictive definition of Indian land. Through this exclusion, United States law denies Alaska Native women equal protection under the law and treats them differently than other women, including other Indigenous women. As a result, Alaska Native women report rates of domestic violence up to 10 times the national average and physical assault victimization rates up to 12 times higher. It goes without saying these levels of violence impact Native nations in profound ways. Usually when Native women are abused, their children suffer as well. National studies show that men who batter their companion also abuse their children in 49 to 70% of cases. 2 recent reports, the 2013 Indian Law and Order Commission report to the President and Congress, and the Attorney General's 2014 Advisory Committee on Alaska Native and American Indian Children Exposed to Violence, similarly found that empowering local communities is the best way to combat and address the extreme levels of violence. Specifically, the Indian Law and Order Commission report notes that public safety in Indian country can and will improve dramatically once Native American nations and Alaska Native tribes have greater freedom to build and maintain their own criminal justice systems. The work of the Indian Law Resource Center has focused on the UN Declaration on the Rights of Indigenous Peoples as a framework for shifting this conversation from creating responsibilities and harnessing that power to implement the rights of Indigenous peoples in their own communities. Our executive director drafted the very first version of the declaration that was presented to the UN in 1977. The UN Declaration was adopted in 2007. It is a historic statement of the rights of Indian and Alaska Native tribes and other Indigenous peoples. It includes the right of self-determination, the right to exist as tribes and distinct peoples, the right of tribes to own their lands and resources, to have enforcement and respect for treaties, protection and access to sacred sites, and most importantly, it recognizes the rights and special needs of Indigenous women and children. It calls for states to take measures in conjunction with Indigenous peoples to ensure that Indigenous women and girls enjoy the full protection and guarantees against all forms of violence and discrimination. Articles 34 and 35 provide further rights on the right to develop your juridical systems as Indigenous peoples, and to determine the responsibilities of individuals in their communities. It is not, strictly speaking, a binding legal instrument, but it is a very powerful influence on the policies and actions of countries, and it has proven to be a powerful tool in combating the epidemic of violence against Native women in the United States. 10 years ago, this conversation wasn't happening, and now we have this issue is at the forefront of a lot of policymakers' minds and at the forefront of a lot of other countries' minds around the world as well. In 2012, the UN decided to hold a world conference to advance the objectives of the UN Declaration. This was a great opportunity. It was historic and rare. It had been 8 years since the Declaration was adopted and 8 years with very little action in the UN to implement the Declaration. So this was a positive UN action that was designed to come to agreement of how to implement the Declaration, to put it into effect and take action to help assure that countries do not get away with violating rights. For more than 2 years, many tribes, 136 Native nations, 23 tribal organizations, and Native women's coalitions prepared for the UN World Conference because it presented a great opportunity to win UN decisions to implement the Declaration and to take other actions benefiting Indigenous peoples. This group of tribal governments and Indigenous organizations joined together with us in demanding or recommending that the World Conference do 4 things, all of which were eventually adopted by the World Conference and included in its final outcome document last year. This was done by consensus. No countries objected, and it was recorded in a General Assembly resolution, the highest action the UN can take. The outcome document is a statement of the commitments of the General Assembly and the commitments of the member states of the UN concerning many issues affecting Indigenous peoples. Now we are working to see that the UN system actually carries out these decisions and commitments. This doesn't happen quickly. Everyone that's worked in the UN knows that things move very slowly, but we are making very serious and hopeful progress in getting the most important decisions implemented in the UN. These decisions include creating an implementing and monitoring body for the UN Declaration. Like I said, it's been 8 years since the UN Declaration was adopted, yet countries have been very slow to move to implement it, to make it real and realizable. It must be such a body should be able to respond to violations of rights by making reports, recommendations, general observations, and country visits. The outcome document of the World Conference requests the Human Rights Council to examine its existing mechanisms to determine which body could become the implementing and monitoring body for the UN Declaration. Last month, we won a decision from the Council to convene a 2-day expert meeting in early 2016 with the goal to review the mandate of the expert mechanism on the rights of Indigenous peoples, and to propose recommendations on how it can more effectively promote respect for the UN Declaration, including by assisting member states to monitor, evaluate, and improve achievement of the ends of the Declaration. The results of the meeting will be considered by the expert mechanism in July, and then by the Human Rights Council in September. There could be UN action as early as September of next year on this issue. We think this body would serve as a monitoring presence in the UN, and would very encompassing, because the UN Declaration reads much like a treaty. There's 46 very clear articles about the rights and responsibilities of Indigenous peoples, UN member states, and the UN itself. The second thing, a permanent status for tribal governments to participate in the UN. There's a long and compelling history of Indigenous governments participating in the UN. My great-grandfather was the first in 1923. Then a large delegation in 1977. The UN has not caught up yet. Indigenous people still have to go as NGOs. So we're seeking new rules to enable the permanent participation of Indigenous governments in the UN, so they can be in the UN to directly defend their rights. The third thing, action to combat violence against women, Indigenous women, is progressing. Last month, we won a decision by the Human Rights Council to hold a panel in September 2016 on the causes and consequences of violence against Indigenous women and girls. We'll work to secure good and useful outcomes from this. We're also working in the Commission on the Status of Women in New York, and they're meeting in March of next year. So this is where international advocacy becomes critical. We will continue to press the international community to take measures to respond to the epidemic of violence against Indigenous women in the U.S. and everywhere, to empower tribal nations, and to ensure that perpetrators of violence against Indigenous women and children are brought to justice. Thank you.